Okay, picture this. A magnificent old mansion, red brick, built with the kind of detail you just don't see anymore.
Hmm.
It sits on a prime piece of land right in the middle of a booming city street lined with towering modern buildings.
Right.
You'd automatically think that property is incredibly valuable and that grand old house on it must only increase that value.
Right. You'd think so. Absolutely. It seems obvious.
But what if, in the complex, sometimes counterintuitive world of property valuation, especially when it comes to calculating land tax, that very same historic building is argued to make the land less valuable?
Less valuable. That's the twist.
Yeah, and what if a dispute over that exact question, whether a building is an improvement that boosts the land's worth or maybe something that actually diminishes its taxable value, sparks this, like, legal marathon?
A marathon that goes all the way from a local tribunal through state courts and ultimately reaches the highest court in the entire country.
Exactly. It sounds almost unbelievable.
Well, that tension, that fundamental question of how you value land when it's constrained by a beautiful but potentially limiting historic structure, is precisely what led to the incredible legal and valuation saga we're diving into today.
Okay.
This deep dive unpacks the case centered around a specific Melbourne property known as Landene. Its very determined owner, WSTI Properties, and the government authority responsible for setting property values, the Valuer General Victoria.
And we've really immersed ourselves in the source material here. We've got the stack of court documents, the detailed judgments handed down by the Victorian Civil and Administrative Tribunal, VFAT first,
Yeah.
then the Supreme Court of Victoria Court of Appeal,
Yeah.
the VSCA,
Mm-hmm.
and finally the High Court of Australia, the HCA. We studied the legal submissions, even got some insights from the actual oral arguments presented to the justices.
Our mission today is really to guide you through this complex battle. We'll introduce you to the key players, explore the property and the planning rules that are, well, absolutely central to the conflict.
Right.
We'll trace the dramatic journey this valuation dispute took through the court system and uncover the crucial legal principle the High Court ultimately clarified.
It's a fascinating intersection of history, urban development, and the real nitty-gritty of valuation law. Okay, let's unpack this. So let's begin by introducing the star of our story, the property itself. As we mentioned, it's called Landene.
Landene, yes. It's a remarkable building located at 490 St. Kilda Road in Melbourne. It's a two-story villa built way back in 1897.
Wow, 1897.
Yeah, showcasing a beautiful Queen Anne-influenced architectural style. And it sits on a pretty substantial parcel of land, 1,046 square meters.
Thinking about St. Kilda Road today, it's a corridor just dominated by high-rise commercial buildings, apartment towers.
Absolutely. Big, modern buildings everywhere.
And the court documents really emphasize that Landene stands out. It's one of the very few remaining fragments of the sort of late 19th century character of that street.
It really is. It's this historical outlier, isn't it? A piece of the past surrounded by the present and, well, the future of the city.
And that historical significance isn't just, nice to look at. It has actual legal implications.
It absolutely does. Landene is subject to a site-specific heritage overlay, HO331 it's called, under the local planning scheme.
HO331.
Okay. And the explicit purpose of this overlay is clear. Conserve and enhance the heritage, character, and significance of Landene. Protect the building, basically.
So Landene is the protagonist, the centerpiece. Now, who are the main participants locked in this legal dispute over its value, this valuation battle?
Okay, so on one side, you have WSTI Properties 490 SKR 80S Ltd. They're the current owners. They purchased Landene back in August 2019 for $8.25 million.
$8.25 million. Okay. And it wasn't just an investment property they sort of left untouched, was it?
No, not at all. The sources indicate they undertook really extensive interior renovations. They actually repurposed the building to function as a private gallery for their collection of art and antiques.
Oh, interesting. So they clearly saw value in the building as a building, not just the land.
Absolutely. It shows they bought it with a specific use in mind, invested significantly in maintaining and adapting the existing structure. They valued Landene as it is.
Right. And on the other side of this fight?
On the other side is the Valuer General Victoria, the VGV. This is the state government authority, and they're mandated by the Valuation of Land Act 1960, that's the VLA, to determine property values every year.
And these values are used for rates and taxes.
Exactly. Local councils use them for rates. The state government uses them for land tax. The VGV acts, in a sense, as the official arbiter of value. And in this case, they were the ones whose valuation was challenged very strongly by the owner.
Okay. And in cases like this, you always have the experts, right? Where technical questions of heritage, planning, valuation methods are just central.
Absolutely crucial. The experts become incredibly important players, presenting their often quite conflicting opinions to the court or tribunal.
Yeah.
In this case, you had heritage consultants, Mr. Bryce Raworth acting for WSTI and Mrs. Zena Beatty for the BGV. For town planning expertise, there was Mr. Tim McBride Burgess representing WSTI and Mr. Andrew Clark presenting evidence for the VGV.
Got it. Heritage, planning, and then the valuation experts.
Yeah.
Their differing conclusions must have really set the stage for the legal fight.
Yes. The valuers were, you could say, right at the very heart of it. Mr. Nicholas Haynes of Matheson Stephen Valuers provided the valuation evidence relied upon by the VGV.
Haynes for the VGV.
And Mr. Grant Jackson of M3 Property was the valuation expert for WSTI Properties.
Jackson for the owner.
And their fundamentally different approaches to valuing the site, especially given the constraints, led to just vastly different outcomes. Huge difference in the numbers.
Right. That's where the core financial dispute lies. So we have our property, the owner, the valuer, and the experts brought in to interpret the technical world of planning and value. Let's delve a bit deeper into the property's constraints, because you said this is the engine room of the entire dispute.
Right, exactly. Landene's location on St. Kilda Road is, well, undeniably prime real estate. The land itself is zoned Commercial 1 under the local planning scheme.
Commercial 1 zoning.
Yeah.
That usually means pretty intense development potential, right? Like shops, offices, maybe apartments.
Yeah, it's typically intended for vibrant mixed-use centers. It allows for significant commercial, retail, even residential development. On a vacant site of this size, over 1,000 square meters in this location, that zoning suggests potential for really intensive, high-density development.
Like a tower.
It absolutely implies potential for a very large building. And complementing that zoning, there are these things called design and development overlays, or DDOs, which guide the built form, the shape and size of buildings.
Okay, more acronyms. DDOs.
Yep. Without getting lost in the specific schedule numbers, there were actually 3 affecting this site, dealing with things like view lines to the shrine and helicopter paths.
Right.
The important thing is that one of them, scheduled 26-5A, specifically permits a building height of up to 65 meters if the site were vacant.
65 meters. Okay, that's significant. That's the potential for a major tower on that spot. If it were just an empty block.
Exactly. Huge potential. But that's where the heritage overlay, that H0331 we mentioned, comes crashing in.
Ah, yes, the heritage protection.
This is the critical constraint that really defines the Landene case. The heritage overlay exists specifically to protect the heritage character of Landene itself. It means you need a planning permit for any external works.
Okay, like adding a balcony or changing windows.
Yes, but crucially, it also requires a permit to demolish or remove the building.
And what do the experts say about the chances of getting that permit? The demolition permit for Landene.
This was a really key point of consensus from the expert evidence, something the courts relied on. Both the heritage experts and the planning experts from both sides.
Both sides agreed.
Yes, they agreed that demolition of Landene would simply not be supported by the local council or by VCAT if it went to appeal. The building must be substantially retained in any future development of the site, period.
Wow. So despite that Commercial 1 zoning, theoretically allowing a 65-meter tower on a vacant site, the reality is Landene sits there, protected, meaning you absolutely cannot just knock it down and build that tower.
Correct. The existing historic building dramatically limits the land's development potential compared to what the zoning alone might suggest on paper.
So the highest and best use isn't a tower anymore.
Exactly. The planning experts did sort of debate the finer points, like the extent of minor additions or alterations that might be possible around the existing building. You know, maybe adding a small extension.
How small?
Well, estimates range from a tiny 18 square meters to perhaps up to 50 square meters of additional floor area, depending on how you interpret setback rules.
Which is nothing compared to a 65-meter tower.
Precisely. It's negligible in the grand scheme of development potential. The heritage overlay fundamentally changes the highest and best use of the land. It transforms it from a potential tower site into a site where the existing historic building must remain. And that's the heart of the valuation puzzle.
And this puzzle, this conflict, first really presented itself in the form of the annual valuations issued by the Valuer General Victoria, right?
That's right. Under that Valuation of Land Act, the VLA, the VGV, assesses various values for properties each year. One of the key values is the site value.
Site value, that's the one used for land tax.
Yes. Site value is supposed to be the value of the land itself, as if no improvements like buildings had been made to it. It's notionally vacant land value, and it's what land tax is based on.
So pretty straightforward. A higher site value means a higher land tax bill for the owner.
Correct. Now, on 1st January 2020, and again on January 2021, the VGV issued its assessment. They returned a site value for Landene of $6.2 million on both dates.
$6.2 million.
For context, the capital improved value, that's the CIV, the value of the land with the building and other improvements, was assessed at $7.2 million in 2020. And the net annual value, NAV, was $360,000.
Okay, so the initial $6.2 million site value was lower than the $7.2 million CIV. Doesn't that suggest the VGV initially did think Landene was an improvement that added value, and they notionally removed that value for the site calculation?
It certainly looks that way from those initial figures, doesn't it? That seems to be the implication. However, WSTI Properties, the owner, felt that even $6.2 million for the site value was still far, far too high.
Why? Because of the heritage constraints.
Precisely because of the constraints imposed by that heritage overlay, HO 331. They argued it dramatically reduced what you could actually do with the land, so the underlying land value couldn't be that high. They formally objected to both the 2020 and the 2021 site valuations.
Okay, so the owner objects. What happens next?
The VGV considered the objections and disallowed them. They stuck to their figure. And when that happens, the dispute escalates. The first stop was the Victorian Civil and Administrative Tribunal, VCAT.
Right, VC. This is the initial forum where all the evidence and arguments were laid out in detail for the first time. The first battleground.
It was. VSAT is often the first port of call for these valuation disputes in Victoria. So WSTI's objection to the 2020 valuation was disallowed, leading them to apply to VCAT for a review that was preceding P1013-2021.
Okay.
For the 2021 valuation, the VGV was sort of deemed to have disallowed the objection because time ran out, triggering a second VCAT application from WSTI P100492-022.
And these were heard together. Saved everyone some time, I guess.
Yes, the two proceedings were consolidated, heard together over 4 days. The panel hearing the case was quite high level. It included Justice Quigley, who was the president of the tribunal at the time, and senior member Giacono, who brought specific expertise in land valuation to the panel.
A judge and a valuation expert on the panel. Sounds like they were taking it seriously. What was the evidence like at VCA?
Well, extensive expert evidence was presented and cross-examined. As we already touched on, the heritage and planning experts actually reached a pretty clear consensus on the facts.
The Landene had to stay.
Yes. Landene must be substantially retained, demolition wouldn't be supported by council or VCAT, and opportunities for significant new development on the site were extremely limited. They also agreed that if, and it's a big if, the heritage constraints weren't there, then yes, large-scale development, maybe 15, 17 stories consistent with the Commercial 1 zoning could be considered. But that if was purely hypothetical because the constraint was real.
So the factual basis about the physical constraints wasn't really in dispute. But the real divergence, the sources really highlight this, was between the valuation experts, Mr. Haynes for VGV and Mr. Jackson for WSTI. They presented starkly different methodologies, is how the judgment put it.
Starkly different is right. And crucially, at VCAT, the VGV, the Valuer General, did not defend their initial return site value of $6.2 million.
Wait, what? They didn't stand by their own valuation notice?
No, instead they relied entirely on the valuation evidence presented by their expert, Mr. Haynes. And his methodology actually led to a different site value conclusion, one that was, in fact, higher than the $6.2 million originally issued.
So the Valuer General effectively went to court arguing their own original valuation was incorrect. Too low even. That seems really unusual.
It does, and it highlights just how fundamental this underlying legal question about the definition of improvement became. It wasn't just about the number anymore. It was about the method and the law.
Okay, so let's unpack Mr. Haynes' method for the VGV. How did he arrive at his higher figure?
Right. Mr. Haynes' methodology started with asking whether Landene, the building itself, qualified as an improvement under the Valuation of Land Act. He argued this required comparing two scenarios.
Okay, scenario one.
Scenario one was the value of the land treated as vacant. And critically, he argued it should be valued as if it were unaffected by the heritage overlay.
Why unaffected? The overlay was real.
His reasoning, which became central later, was that the heritage overlay only exists because of the building. If you notionally remove the building for site value, you should also notionally remove the constraint that depends on it. So he assessed this hypothetical vacant unconstrained site value based on comparable sales of development land and the planning evidence about the potential 1517-story yield. He put this value at $12.825 million as at 1 January 2020.
$12.8 million. Okay, that's the land's highest potential value if the building and its protection just vanished. What was scenario 2?
Scenario 2 was the value of the land with the existing building and works on it, having regard to comparable sales in what he termed the heritage market. At $8.25 million from August 2019 as the indicator of this non-vacant land value.
Okay, so $12.8 million for hypothetical vacant unconstrained land versus $8.25 million for the land with the building and its constraints. What was his conclusion from comparing these?
His conclusion was stark. Since Scenario 1, $12.825 million, yielded a higher value than Scenario 2, $8.25, the building and works, Landene, did not, in his view, increase the value of the land when compared to that unconstrained vacant potential. Therefore, he argued, Landene was not an improvement according to the VLA definition.
Right, because an improvement, by definition, has to increase the value. And he's saying, compared to the highest possible use, it actually decreases it.
Exactly. And under the VGV's interpretation, if a building isn't an improvement, what happens in the site value calculation? Where does its value go?
Well, if it's not notionally removed as an improvement, then its value must effectively be included within the site value, right?
That was precisely the VGV's position, based on Mr. Haynes's report. If Landene wasn't an improvement, its value remained part of the site value. So Mr. Haynes concluded the site value should be equal to the non-vacant land value, which he took as that $8.25 million purchase price for 2020.
So he ended up arguing for an $8.25 million site value, higher than the $6.2 million they originally issued.
Yes. Although there was a slight adjustment later. Mr. Haynes acknowledged an error regarding renovation costs WSTI undertook after buying, about $1.285 million, which he did consider improvements. So his final adjusted site value for 2020 was closer to $6.965 million, and for 2021 it was $8.25 million. But the core argument remained. Because the building's suppressed value compared to the vacant, unconstrained potential, it wasn't an improvement. And thus the site value should be much, much higher than WSTI contended. It should reflect the value with the building, not notionally without it.
Okay, that's a complex argument, but I think I follow.
Yeah.
VGV's valuer says site value is high, around $7–8 million, because the building isn't an improvement by his test. What about WSTI's valuer, Mr. Jackson? How did he approach it?
Mr. Jackson took a completely different starting point. He approached it from the perspective of the land's highest and best use in reality, given the unavoidable heritage constraints.
So starting with the world as it is, not a hypothetical world.
Exactly. He recognized that the highest and best use had to incorporate the retained Landene building. You couldn't ignore it. So he used methods like analyzing sales of comparable properties with buildings and with similar heritage constraints. He also used a hypothetical development analysis, but one that factored in the heritage limitation from the start.
Okay.
He essentially calculated a residual site value. He looked at the market value of the constrained property as a whole, and then deducted the replacement cost or value contribution of the building to arrive at the underlying land value.
So his method started with the market value of the property as it exists, with the building and the real-world constraints, and then worked backwards to find the land component's value.
Precisely. And his assessed site value was dramatically lower, just $1.340 million for both 2020 and 2021.
1.3 million versus, say, 7 or 8 million. That is an enormous difference.
Huge. And it all hinged entirely on this legal question. Is Landene an improvement under the Valuation of Land Act? And crucially, how do you apply that test? Do you compare it to hypothetical unconstrained land, like Haynes did? Or do you assess its value contribution within the actual constrained reality, like Jackson did?
The central question at VCAT, as Mr. Haynes himself put it in his report, was the differing approaches to how buildings are designated as improvements under the VLA definition. This was the absolute crux of the legal battle.
VCAT heard all this evidence, considered the legal arguments about the definition of improvements and how it interacted with another part of the Act, Section 5A, which specifically requires valuers to consider planning schemes and highest and best use.
Section 5A. Okay, that sounds important.
It is. And VCAT ultimately rejected Mr. Haynes' methodology, the VGV's approach of comparing an unconstrained vacant site to an encumbered improved one. They didn't accept that comparison.
Why did VCAT disagree with that approach? What was their reasoning?
VSAT held that Section 5A, which directs valuers to consider the planning scheme and highest and best use at the valuation date, is actually the primary guiding provision of the VLA. It sets the context.
Right.
They found the VGV's argument that you decide if something is an improvement before you even consider the real-world planning context dictated by Section 5A was, in their words, untenable.
Untenable. Strong word.
Yes. VCAT reasoned that the correct way to determine if improvements increase value is, and I'm quoting loosely from their decision here, to compare the market value in its full current state, that is, including its limited development potential and existing structures, with the market value that the land would have with the same development potential without the buildings on the land.
Okay, let me process that.
Yeah.
VCAT said you have to value the land with the constraints baked in. The heritage overlay is real. Then you compare the value with the building in that constrained reality to the value without the building, but still subject to the same constraints.
Exactly. They said the comparison must be made within the actual planning context. You look at the value the building adds in the context of those real-world limitations.
So, does Landene add value compared to an empty block that is still subject to the heritage rules?
Well, VCAT found that, yes, applying this test, Landene did add value to the land within the constraints. An empty block under those rules might have very limited use, whereas the existing building allowed for use as a gallery, residence, etc. So VCAT concluded Landene was therefore an improvement.
Okay. And if it is an improvement under VCAT's test?
Then its value is notionally removed to arrive at the site value. VCAT largely adopted Mr. Jackson's methodology, finding it consistent with their interpretation of the VLA, though they did make some adjustments to his final figures based on their own assessment of the evidence.
Right. So what was the final outcome of the VCAT hearing? The final number?
VCAT determined the site value for both 1 January 2020 and 1 January 2021 to be $2.925 million.
$2.9 million. So much lower than the VGV's original $6.2 million, and vastly lower than the nearly $7-8 million Mr. Haynes argued for.
Exactly. VCAT found the original $6.2 million return value was too high and ordered it reduced to $2.925 million. This was a clear, decisive victory for WSTI Properties at the first hurdle. It meant a significantly lower land tax liability based on VCAT's ruling.
A major win for the owner at VCAT. The site value slashed by more than half from the original assessment. But knowing these kinds of cases, the Valuer General Victoria wasn't just going to roll over, were they?
No, definitely not. The VGV wasn't ready to concede defeat, especially on what they saw as a crucial point of legal principle about how improvements are defined. The dispute moved up to the next level: the Supreme Court of Victoria, Court of Appeal, the VSCA.
The state's highest court for most appeals.
That's right. VGV sought, and was granted, leave to appeal VCAT's decision to the VSCA. They argued that VCAT had fundamentally misinterpreted the VLA definition of improvements. The appeal was heard on 1 March 2024 by a panel of 3 senior judges: President Emerton, Justice Kennedy, and Justice Lyons. Judgment was delivered later on 4 July 2024.
Okay, so what were the core arguments VGV put to the Court of Appeal? Was it the same argument as a VSCA?
Essentially, yes. VGV maintained that VCAT had got the legal test for improvement wrong. They reiterated their argument that the comparison should be between the land with the building as it is, with its constraints, and the land as vacant, and therefore they argued free from the heritage constraint that only exists because of the building.
The hypothetical unconstrained vacant land comparison again.
Yes. They argued the building's suppressed value compared to this vacant potential, therefore it wasn't an improvement, and therefore the site value should be much higher, effectively closer to the capital improved value, CIV, or perhaps even that higher vacant land value Mr. Haynes had calculated. They wanted VCAT's decision overturned.
And WSTI, the owner, presumably defended VCAT's position.
They did. WSTI argued that VCAT's approach, which factored in the real-world planning constraints and highest and best use from the outset, was the correct interpretation of the Act, particularly Section 5A. They contended that Landene clearly did add value in the context of those constraints.
Or did they have another argument?
They also had an alternative argument, sort of a fallback position, saying that even if VCAT's primary reasoning wasn't perfect, Landene still added value compared to the land's natural state, before any development occurred back in the 19th century, and that alone should be sufficient for it to be classified as an improvement.
Okay, the natural state argument. I come back to that.
Yeah.
So the VSCA heard these competing arguments. What was the outcome? Did they agree with VCAT?
Well, the VBCA granted leave to appeal, meaning they thought there was an arguable case, but ultimately they dismissed VGV's appeal.
Dismissed it. So WSTI won again.
Yes. Dismissing the appeal meant that, just like a VCAT, the final valuation figure of $2.925 million was upheld. So, same outcome, same number.
Okay, same final number as VCAT. But did the Court of Appeal agree with VCAT's reasons for getting there? You mentioned WSTI had alternative arguments.
This is where it gets really interesting, and frankly, quite complex. It shows just how tricky interpreting these old statutes can be. The VSCA actually disagreed with VCAT's primary reasoning.
They disagreed with VCAT but reached the same result. How does that work?
They found a different path to the same destination. The VSCA disagreed with VCAT's view that the improvement test started with assessing the highest and best use at the valuation date under Section 5A. Instead, the VSCA came up with a novel interpretation of the definition of improvements in Section 2.1 of the VLA.
Section 2.1, what does that take it?
It defines improvements as work actually done or material used, but insofar only as the effect increases the value of the land and the benefit is unexhausted at the time of the valuation. The VSCA focused on that wording and said it actually refers to two distinct points in time.
2 points in time. Okay, that sounds like a completely different way of looking at the definition compared to VCAT or the VGV.
It was a totally different temporal analysis. The VSCA held that the first point in time was way back when the work was actually done, so when Landene was built in 1897. The question then was, did building Landene increase the value of the land at that time compared to its natural state, the land as it was before any human intervention?
Okay, fit it.
The court found that, yes, obviously, building Landene did increase the value of the land back in 1897 by enabling its economic use as a grand residence. So condition 1 met.
So it was an improvement the moment it was finished over a century ago. What was the second point in time the VSCA identified?
The second point was the time of the valuation, so 1st Jan 2020 and 1st Jan 2021. The question here, according to the VSCA, was whether the benefit of that work done in 1897, the value added back then, was unexhausted at the time of valuation.
Unexhausted benefit, meaning is the building still useful? Still providing some value?
Essentially, yes. The VSCA found the benefit was unexhausted, as Landene continued to serve a useful economic purpose, first as accommodation for many years, and now as WSTI's private art gallery. It wasn't derelict or useless.
Okay, so under the VSCA's unique interpretation, Landene was an improvement because, 1, it added value when it was built in 1897, and 2, that benefit is still relevant or unexhausted today.
Precisely. And crucially, under this interpretation, it didn't matter if, compared to a hypothetical tower site today, Landene might appear to suppress the land's maximum potential value. The test was historical increase plus present benefit.
That avoids the issue the VGV was raising, doesn't it? About functional buildings becoming worsements.
Exactly. The VSCA explicitly noted it would be anomalous if subsequent changes in planning laws or market conditions could suddenly turn existing functional buildings into worsements that weren't considered improvements, thereby potentially causing huge, unexpected jumps in site value and land tax. Their interpretation neatly avoided that outcome by anchoring the increase in value test back in history.
So, fascinatingly, the VSCA reached the same conclusion as VCAT, that Landene is an improvement, but through a completely different legal pathway. A pathway focused on the building's effect when it was originally constructed, not its effect on highest and best use today.
Correct. And because they agreed with VCAT, albeit for different reasons, that Landene was an improvement, they saw no reason to interfere with VCAT's final valuation orders, setting the site value at $2.925 million.
So WSTI Properties had won again, defending the VCAT decision at the Court of Appeal, 2-0 to the owner.
Looks like it, but this wasn't the end of the road. The Valuer General Victoria felt this fundamental question about the definition of improvement, specifically the timing of the value test, was of such significance, not just for Landene, but potentially for many other properties, that it warranted clarification from the highest court in the land.
They decided to go again to the High Court.
Yes, the battle for Landene's valuation went all the way to the High Court of Australia in Canberra.
Wow. Taking a state valuation case to the High Court is pretty rare, isn't it? You need special leave to appeal.
It is rare. Special leave is only granted for cases that raise significant questions of law, or where it's necessary to resolve differences of opinion between state courts, or if it's otherwise in the public interest. The fact that leave was granted here really underscores the perceived importance and difficulty of this legal puzzle surrounding the definition of improvements.
Okay, so the High Court agreed to hear it. Who were the judges?
The case, M96/2024, was heard by a full bench of 5 justices: Chief Justice Gagler, Justice Gordon, Justice Stewart, Justice Gleeson, and Justice Jaggett. The hearing took place on 7 March 2025, and the judgment followed a few months later on 11 June 2025.
And what was the absolute core question before the High Court? What did it all boil down to at this final stage?
It boiled down almost entirely to the proper construction of that definition of improvements in the Victorian VLA, specifically. That tricky clause, insofar only as the effect of the work done or material used increases the value of the land. The crunch question was, did that increase in value need to be assessed at the time the work was done, way back in 1897, as the Court of Appeal VSCA had held?
Right. Or did it need to be assessed at the time of the valuation in 2020 and 2021, as the Valuer General, VGV, had argued all along? That was the key legal knot the High Court needed to untangle. When does the increase in value test apply, then or now?
Okay. Let's turn to the arguments presented to the High Court justices. The sources give us some real insights here, especially from the oral arguments. For the appellant, the Valuer General Victoria, their counsel was Mr. David Batt KC. What was his line of attack?
Mr. Batt KC argued forcefully that the VSCA was simply wrong in its interpretation. He contended that the increase in value test for determining if something is an improvement must be applied at the time of the valuation.
Why? What was his reasoning?
He pointed to the historical context of the Victorian Act and related legislation in New Zealand and the Commonwealth, arguing they all implicitly required assessment at the valuation date. He argued the VSCA's two-point-in-time interpretation was unworkable, especially in the context of annual valuations mandated by the Act, and that it led to what he called anomalies. What kind of anomalies did he mean? The same ones the VSCA tried to avoid.
Kind of the flip side. He argued that the VSCA's approach meant that buildings which might today significantly suppress the value of prime development land compared to its unencumbered potential would still be considered improvements just because they added some value when built over a century ago. He painted a picture saying in oral argument something like, having disregarded it, the Worstment building, I have a prime development site value, 80 million. Worstments will be disregarded, site value will be increased compared to capital improved value, and that is a distortion of the system. He basically contended that improvements should logically be structures that enhance value at the relevant time, not items which depress its value compared to the land's best potential use now.
He was doubling down on the argument that if the test is applied now, Landene actually reduces the value of the land compared to its highest potential use as a tower site, if the heritage overlay vanished with the building. Therefore, it's not an improvement.
Precisely. He really hammered that point. He highlighted the expert consensus that without the building, the heritage overlay would have no effect. He argued, and I'm quoting again roughly from the oral arguments transcript, all the development that a reasonable purchaser might seek to undertake on that 1,000 square meter site on St. Kilda Road was available, absent the building. That is why we say the land value was not increased, but rather decreased by the building.
Okay. And if it's not an improvement under his test it now approach, then according to VGV's interpretation, it gets included in the site value calculation.
Yes, that was the logical consequence he argued for. If Landene isn't an improvement, then it remains notionally present when calculating site value. And what does that mean? Mr. Batt argued his pathway home, as he termed it, during the hearing. Because Landene was not an improvement, Landene is to be seen to be present when one comes to evaluation step 3. Therefore, site value by definition equates to capital improved value.
But site value equals CIV.
That was his contention. He noted the CIV was $7.2 million and hadn't been challenged. Therefore, he argued, the original $6.2 million site value issued by the VGV was actually too low, the owner's objection should have been disallowed right back at the start, and the VGV's appeal should be allowed by the High Court.
A bold argument saying their own initial valuation was wrong, but in the owner's favor. Did he acknowledge this was maybe a new angle?
He did, somewhat. When questioned by Chief Justice Gagler, Mr. Batt acknowledged that this specific pathway home argument site value equals CIV, because it's not an improvement, hadn't been fully articulated in quite that way before the Court of Appeal below.
Okay, so that was the VGV's case.
Yeah.
How did counsel for the respondent, the owner WSTI Properties, Mr. Sandro Goubran, respond to these arguments? How did he defend the Court of Appeal's decision?
Well, Mr. Goubran primarily defended the VSCA's interpretation, the 2 points in time theory. He argued that the specific wording of the definition, separating the increase in value from the unexhausted benefit at time of valuation, logically pointed to 2 different temporal assessments. He also argued the legislative history supported this bifurcation.
So stick with the Court of Appeals reasoning. Value increase tested back then. Benefit tested now.
That was his main line, but he also had that alternative natural state argument ready just in case the High Court wasn't persuaded by the two times interpretation.
Right, the fallback. What was that again?
He argued that even if the increase in value test is applied at the date of valuation now, the comparison isn't necessarily with the land's hypothetical highest development potential, the tower site. He contended the test only requires showing the building increases value compared to the land in its natural undeveloped state as it was before any human works.
Okay, so compared to just bare earth, Landene definitely adds value, even today.
That was the argument. He cited some NSW case law, like Commonwealth Custodial and Trust Company, suggesting that the established approach elsewhere was to compare the structure's value add to the natural state, considered at the time of valuation. He argued Landene clearly met that threshold.
So two main arguments from WSTI. Either the VSCA's two times approach was right, or even if you test value now, the comparison is only against the natural state, not the highest potential use.
Exactly. He also tried to push back against VGV's approach by arguing they were conflating two distinct steps. He said the first step is just a binary question. Is it an improvement? Yes or no. You only get to the amount of value later in the calculation, quoting him roughly. The prior exercise is just simply to determine whether the building is an improvement. It is not asking you to determine the amount, it is simply requiring the threshold be satisfied.
Trying to separate the classification from the quantification.
Precisely. And the justices, as you'd expect, really put both counsel through their paces, keenly probing these complex arguments.
Can you give some examples?
Sure. The sources show Chief Justice Gagler questioning Mr. Batt about the policy implications of his argument and that pathway home possibly being raised late. Justice Stewart pressed Mr. Goubran on exactly where the natural state comparison test was explicitly stated in the Victorian Act's definition, as opposed to perhaps NSW law. And Justice Jago seemed particularly focused on the temporal element, questioning the logic of the VSCA's two-point-in-time analysis and how it compared with other jurisdictions. She asked questions suggesting skepticism, like, but there is embedded in that you cannot value other than at a time, and to have the relativity, you need to have time. It was clearly a very rigorous examination of the precise wording, history, and logic of the VLA definition.
A real deep dive by the High Court itself. So after considering these intricate arguments, dissecting the statute, what was the High Court's ultimate decision? The judgment came down in June 2025 HCA 23. What did they rule?
The High Court allowed the appeal.
Allowed the VGV's appeal, so they overturned the Court of Appeal.
Yes. They set aside Order 2 of the VSCA's decision, that was the order that had dismissed the VGV's appeal, and they remitted the matter, meaning they sent it back down to the Victorian Court of Appeal for determination according to the High Court's judgment.
Okay, they allowed the appeal and sent it back. What does that signal about their view on that core timing question? When do you test the increase in value?
Well, while we'd need the full written reasons to see the precise step-by-step legal analysis, the fact that the High Court allowed the VGV's appeal is a very, very strong indication. It strongly suggests they disagreed with the Court of Appeal's central interpretation regarding the timing of the increase in value test.
They rejected the VSCA's two-points-in-time theory.
It seems almost certain. By allowing the VGV's appeal, the High Court has effectively endorsed the position argued by the VGV all along, that the assessment of whether a building constitutes an improvement under the VLA hinges on whether it increases the land's value at the time of the valuation, not predominantly based on when it was built over a century ago.
Wow. Okay, that fundamentally changes the legal landscape compared to both VCAT's initial decision and especially the Court of Appeals reasoning.
It absolutely does. The High Court, it appears, has provided definitive clarity on this specific, crucial point of law under the Victorian Valuation of Land Act. The test for improvement, specifically the increase in value part, is applied at the valuation date.
So what does this High Court decision mean in practice, both for Landene specifically and maybe more broadly for property valuation in Victoria?
Okay, well, the most significant legal principle clarified is exactly that. When determining if a building is an improvement that gets notionally removed for site value calculation under the VLA, the key question is whether its presence increases the land's value at the date of valuation. And this assessment must be made considering the applicable planning controls and the land's highest and best use in that contemporary context compared to its value without the building. But, crucially, subject to the same planning constraints that would apply to the vacant land. The VSCA's historical timing test has effectively been overruled on this critical point.
For Landene itself, what happens now? Does the High Court set the value?
No, the High Court didn't determine a new valuation figure. As we said, it remitted the case, sent it back to the Victorian Court of Appeal. The VSCA must now essentially rehear or redetermine the VGV's original appeal from the VSAC decision.
But this time,
they must apply the High Court's interpretation of the law that the increase in value test for improvement is applied at the valuation date, 1st Jan 2020 and 1st Jan 2021.
so based on the High Court's implied reasoning, which sided with the VGV on the timing issue, is it likely or even inevitable that the VSCA will now find that Landene is not an improvement?
Given that the High Court's decision aligns directly with the core of VGV's argument about the timing, yes, it seems highly probable. The VSCA, applying the High Court's binding direction, will likely be required to find that Landene is not an improvement.
Why again? Remind us of that logic.
Because VGV's argument, now seemingly endorsed on the timing point, was that when assessed at the valuation date, Landene actually suppresses the land's value compared to its highest and best use potential if it weren't there, and the dependent heritage overlay therefore also wasn't there. The $8.25 value with Landene was less than the $12.08 meters potential without it.
Okay. And if Landene is now deemed not an improvement by the VSCA, applying the High Court's rule, what are the financial implications for the site value?
If it's not an improvement, then under the VLA, its value is included in the calculation of site value. This could well mean the site value reverts towards those much higher figures argued by the VGV's valuer at VCAT. Perhaps the $7.2 million capital improved value, CIV, that Mr. Batt cited in the High Court as the likely outcome of his pathway home argument. Or maybe the adjusted $6.965 million, $8.25 of figures Mr. Haynes arrived at.
So a potential site value may be 3 times higher than the $2.925 million determined by VCAT and initially upheld by the VSCA.
It certainly seems possible, even likely. That would obviously mean a significantly higher land tax bill for WSTI properties retrospectively for those years and potentially going forward. A dramatic reversal of fortune.
This specific case clearly has huge implications for the owner, but does it resonate more broadly, beyond just Landene?
Oh, absolutely. This is a landmark decision. It clarifies a fundamental point of Victorian valuation law, and it's particularly relevant for properties across the state that have significant heritage constraints limiting their development potential on otherwise valuable land.
Like many properties in historic inner-city areas.
Exactly. It highlights that inherent tension in valuation law, valuing land based on its theoretical highest potential versus valuing it based on its constrained reality when historic structures must be preserved. The High Court's clarification on the timing of the improvement test will directly influence how thousands of similar heritage properties are valued for rates and land tax purposes across Victoria.
And maybe elsewhere.
Potentially. While it's based on specific Victorian legislation, High Court interpretations can certainly have persuasive influence in other Australian states or territories that might have similar valuation statutes with comparable definitions of improvement. It underscores the complex, delicate interplay between private property rights, public heritage preservation goals, urban development pressures, and the laws designed to tax land value.
It's really a powerful illustration, isn't it? How the interpretation of just a few words increases the value of the land in a decades-old piece of legislation can trigger years of complex, expensive litigation involving multiple courts, senior barristers, expert witnesses.
And ultimately have major financial consequences for property owners and potentially significant impacts on government revenue from land tax.
It truly is a deep dive into the mechanics of how legal definitions shape our economic reality and our understanding of property value.
Indeed, it shows how law and valuation intersect in really critical ways.
So let's just trace that incredible journey one last time, put it all together. It began simply enough with an annual rates notice from the council and an objection by the owner, WSTI Properties, to the Valuer General's $6.2 million site valuation for Landene.
The owner felt it was far too high, given the strict heritage overlay preventing demolition or major redevelopment.
That objection was disallowed, leading to a 4-day hearing at VCAT. VCAT sided with the owner, finding Landene was an improvement under their interpretation of the law, comparing value with and without the building within the constraints, and slashed the site value to $2.925 million.
A big win for WSTI. But the Valuer General appealed to the state's Court of Appeal, the VSCA.
The VSCA, fascinatingly, upheld the $2.925 million figure, so WSTI won again. But the VSCA did so based on a completely different interpretation of the law. their novel 2 points in time theory, focusing on Landene adding value back when it was built in 1897, and that benefit remaining unexhausted today.
Still not satisfied, particularly with that timing interpretation. The valuer general took the fundamental legal question: when do you test if a building increases land value to be considered an improvement under the VLA, all the way to the High Court of Australia?
And the High Court, in its 2025 judgment, effectively answered. You test it now at the date of valuation.
Yeah.
By allowing the VGV's appeal and sending the case back to the VSCA with that direction, the High Court has clarified the crucial timing element.
So the final chapter for Landene's 2020 and 2021 site valuation figure will now be written back at the Victorian Court of Appeal. But this time, the VSCA must apply the High Court's rule, which very likely means finding Landene is not an improvement, leading to a return to a much higher site value, closer to the figures the VGV argued for all along.
An extraordinary legal battle over the meaning of improvement and the economic value of history in a modern, developing city.
It really was a valuation saga for the ages.
So here's something to think about. In rapidly growing urban centers like Melbourne or Sydney or many others, where land value is so often driven by the potential for greater height and density, how does a law strike that balance? How does it balance taxing that theoretical development potential against acknowledging the very real limits imposed by preserving significant historic buildings like Landene? When is a building truly an improvement that adds value in the eyes of the law? And when might its presence, viewed through the cold, hard lens of hypothetical highest economic use, actually be seen as something that reduces the taxable value of the land underneath it?
That's the multi-million-dollar question, isn't it?
It is. The High Court has given us crucial clarity on when you ask that question in Victoria, you ask it now. But that underlying tension, that push and pull between development potential and heritage preservation in the world of property valuation, that remains a really complex and fascinating challenge. What stands out to you about this deep dive